Good evening, everyone, and welcome to the regular meeting of the Portsmouth Zoning Board of Adjustment for the month of January. We have an interesting agenda this evening. Before we get actually into items, I have a couple of comments which I hope will be useful. One is the Artwell LLC, the owner of property at 437 Lafayette Road, has withdrawn their application. Therefore, it will not be heard tonight, and any further action on that will require an entirely new application from the beginning. Secondly, the order of business this evening will be presentations, if there is one, limited to 15 minutes, as our rules and regulations state, with the exception that someone may request an additional 5 minutes before they start speaking if they feel that that's necessary. And then subsequent speakers, when we get to the to, for, or against section, will be at 5 minutes, on 5 minutes, without, and you can speak more than once in that session. So, as I've kind of hinted, the order of business will be the presentation by the applicant or the applicant's representative, or as many as they want, limited to a cumulative 15 minutes, and then speakers in favor, then speakers against, and then speakers just to. So that's the order of business. And with respect to attendance, we have obviously here, and those of us here in the room, on live television, and in present. And we also feature Zoom coverage using the Zoom technology. And I'm going to ask Mr. Stith from the Planning Department to explain that part of our program.
Thank you. For those participating on the Zoom call, if you would like to comment on a public hearing, please wait until that portion of the hearing is before us, and then you can use the raise hand icon to indicate that you would like to speak. We will call on you and allow you to speak and participate and make your comments.
Thank you. Fourthly, I'd like to get the sense of the board on the election of a new vice chair. Excuse me. My proposal is to postpone that to next month's regular meeting, the February meeting. And if that's acceptable, I'd like someone to make a motion to that effect, and a voice vote will be sufficient.
Mr. Chair, I'd move we postpone that to the following month.
Thank you, Mr. Lee. Is there a second to that motion?
I'll second.
Thank you. Thank you, Ms. Eldridge. All right, any further comments? None? A vote in favor of that proposal, please?
Aye.
Aye. All ayes. Any nays? No? Okay, carried. That's what will that be on the agenda for next month. Excuse me. And the last preliminary item for the evening is with respect to 389 Lincoln Ave, a request to postpone. And in the interest of time, I propose that be taken out of order in the agenda. If someone wants to make that motion, please.
So moved.
Thank you. Second?
Second.
Second, voice vote. Take that out of order?
Aye.
Aye.
Okay. And the motion is to postpone. I think a voice vote, excuse me. Voice vote on this will be sufficient. Those in favor of postponing as requested by the applicant, say aye, please.
Aye.
Aye. Thank you very much. Okay. That takes care of those initial items. Then moving into the items on the agenda. Number one is approval of the minutes of the meeting December 21st, 2021. And as everyone has an opportunity, I hope, to read the minutes, those of you who are here. And if there is a motion to amend it or to approve it as written, would someone do that, please?
I'd like to move to approve the minutes as written.
Thank you. Anybody else? Second on that motion, please?
I'll second.
Thank you, Ms. Margison. Okay, let's do a voice vote. Let's do a roll call vote on that, starting down with Mr. Lee.
Yes.
Mr. Rossi,
Yes.
Ms. Eldridge,
Yes.
Ms. Margison,
Yes.
Mr. McDonald,
Yes.
Mr. Hagerman.
Yes.
And Mr. Mantle.
Yes.
Thank you very much, and I'm not voting because I wasn't here. Thank you. Those are approved. So that leads us right into the first item. We have three items under, for the general public's interest, we have three items under old business and three items under new business. One has already been the withdrawal for 437 Lafayette, leaving two items, the first of which is, excuse me, an item that reads as follows: 132 and 134 Middle Street, LLC, and MAC Properties, the owners, for the properties located at 132 and 134 Middle Street, request a one-year extension on variances granted on February 19th, 2020. The current expiration is February 19th, 2022. Said properties are shown on Assessor Map Lot 172, Lot 12, and Map 127, Lot 11, and lie within the Character District. 4-L1, CD4, L1. So they're asking for a one-year extension, and they're asking in a timely fashion. And could we have a brief presentation as to the reason for this request?
Sure. Mr. Chairman, members of the board, for the record, Attorney Derek Durbin. I'm here on behalf of the applicant. The applicants were granted certain variance relief for the expansion of a nonconforming use at 132 and 134 Middle Street on February 19th of 2020. Basically, it involves one building that straddles both property. It's partitioned in the middle, right on the property boundary line. My client is basically proposing to go in and do a full-scale renovation, which also involves adding one unit to the total unit count on the property. As a result of the pandemic and all the factors associated with that, including rising prices, lack of labor, also you have a fully occupied building with tenants in it. My client has not been able to perform that full-scale renovation of the building at this time. Therefore, they're before the board tonight seeking. I put a 2-year request in. I know that probably is going to look aggressive to the board. In the past, historically, you've granted 1-year extensions. I just did that because I know that there's a possibility we could be here another year from now asking for a similar request based on the way things are going. My client hopes to get it done the next year, but I requested 2 years just to hopefully just get ahead of it, really. But I also understand if the board's not comfortable with that, if the board's considering approving a request for an extension. So that's really what I have, unless there are questions from the board.
Thank you. Any questions from the board? Mr. McDonald?
I'm not clear on how long the extension you're asking for. Are you asking for 1 year or 2 years?
I was asking for a 2-year extension. I just was noting that historically the board has granted 1-year extensions. Yeah.
A 2-year extension would be an extension beyond what has been approved so far.
An extension, so 2 years from when the approvals expire, which is February 19th, 2022. So, yeah,
Okay.
that's correct.
Just want to know what
Yep, sure.
what
Yep.
we're doing.
Thank you.
Anybody else? Ms. Margison?
The zoning provision actually allows for a 2-year extension. It's 10.236.
Right.
And it says it shall expire unless obtained within a period of 2 years.
It's,
That's right.
then they can do a one-time 1-year extension. Is that what the ordinance reads?
But basically, he's just asking for a 2-year extension prior to the expiration of these variances.
Yeah, that's correct. It's just, I think there's just sort of been a gloss applied by the board in the past of 1 year. I just came forward with 2 to hopefully get ahead of it. I just know this is a big renovation project for that building, and trying to remove tenants or find alternative housing for them, and also get done what needs to be done here is a pretty big undertaking.
Mr. Sis? Yeah.
Well, so the ordinance says the board may, for good cause shown, extend such period by as much as 1 year if
Oh, it
such
does, okay.
extension is requested and acted upon prior to the expiration date. no other extensions may be requested.
Okay, I wasn't aware of that provision, but yes, okay, then it would be a one-year request, essentially modified to a one-year request.
That would be consistent with the agenda. Okay, very good. Thank you. Is there any?
I just want to put it out there, though, that this could potentially, we may end up having to come back. So I just would note that for the record.
And so all that's required would be to obtain a building permit.
Yes, correct,
Right.
yeah.
Any further comments, questions, anything from the board? No? Thank you very much.
Thank you.
Anyone present who wish to speak in favor of this proposal,
It's not a public hearing.
request? Okay,
It's
that's
not a
right.
public
That was not a purpose. That's right, sorry. Yeah. Okay. Getting ahead of myself here. All right. Hey, a motion?
A question, Mr. Chair. Can I just get clarification on which alternate is sitting on this case?
Yes. You.
Okay.
Thank you. I knew I had one other thing on my plate to do. Okay, thank you.
In which case, I'll make a motion to grant the one-year extension.
Thank you. Is there a second to that motion? Mr. Lee, thank you. Your motion, please.
I think the reasons brought forth requesting the extension make sense. It's a difficult time right now for building and as a result of COVID, and it's also built into our ordinance. So with that, I would support granting a one-year extension.
Thank
I
you.
understand the reasons for two, but sticking with one.
Thank you. Mr. Lee?
Well, having just completed rehabbing an apartment, I'm in total sympathy with anybody doing any construction work in Portsmouth right now, so I would be happy to second that motion.
Thank you. Anything further? Any discussion on the board? If not, we'll take a vote. We'll start down this end this
Just a
time.
clarification, Mr. Chair.
I'm sorry,
So it's
Ms.
for a
Mayor.
one-year extension.
1-year extension, yes, as per the agenda, yes.
And the motion is to grant.
It's to grant 1-year extension from.
Aye.
Thank you.
Yes.
Mr. McDonald?
Yes.
Ms. Margison?
Yes.
Ms. Eldridge?
I think it's Mr. Rossi.
Oh, sorry, that's right. Mr. Rossi?
Yes.
I'll get this yet. Mr. Lee?
Yes.
And the chair acts, votes yes as well. The motion is carried. The 1-year extension is granted. Thank you. Okay. The second item under the heading of old business this evening is a request for reconsideration of rehearing at 53 Green Street. Does anyone on the board want to make some comments on, open the discussion on this, to get us rolling on this issue? I don't anticipate, no change we don't anticipate speakers. So, Ms. Martison?
Mr. Chair, I think, which alternate is going to vote on this?
We might as well take you might as well alternate, yeah, Ms. Eldridge, you're in.
So I did a lot of research on this. I voted against the motion for rehearing. I continue to think that it should not have been granted. However, I see nothing in my research that says that we can entertain a motion for reconsideration of a motion for rehearing. The RSA is 677. Our rules do not anticipate any such event, and I do not think that we can actually entertain a motion for reconsideration. From my research, it seems that we need to go into, not tonight, but actually it needs to go, just have a rehearing on it.
Okay,
So it's not even to the merits of the attorney's, presentation on both sides. It's just that I see nothing in RSA 677 that allows us to do a motion for reconsideration.
okay. Who else would like to address this motion, this issue, excuse me?
Should we speak to the merits of it, or should we?
Well, it's just a motion to, it's a request, it's specific to reconsideration of the rehearing, so we can't really, I don't think yet, and correct me if I'm wrong, but I don't think we can get into the merits of the issue itself.
Right.
I have a question. So if there's nothing that permits it, is there anything that prohibits it?
go ahead.
As I read, the BOA is a jurisdictional board. We can only act according to grants of power under the statutes and under the rules, and I do not see anything that allows us to do it. I mean, that's my opinion. Others should weigh in.
Mr. McDonald?
Question. We're not hearing anyone from either side of this issue here to either defend or defeat this. Do we know why? Did they lose interest? Where are they?
Oh, no.
No, this is more of a deliberation among the board, kind of like a request for rehearing.
Okay.
Yeah. Just procedural, yeah.
It's a request on the request.
Request of a request of a request, yeah. That's right. Or a rehearing, yeah. Say that fast, 3 times. Anybody else? Over here?
In the audience, there's one.
May I just make clear, there is somebody here from the
Not a public hearing, sorry. I wish it were, it's not. Anybody else over here? Any further thoughts on the subject? No? Well, in that case, does someone have a motion? If we don't have any further discussion, maybe a motion is in order, and then we can discuss the motion. Ms. Margerson?
I would move that we deny the motion for reconsideration for a motion for rehearing for the reasons I stated previously. There's nothing in the RSAs or in our rules that allow us to entertain such a motion. That's all.
All right. Is there a second to that motion?
I'll second
Miss-
it so we can.
Ms. Eldridge, yes, thank you for that. Okay, Ms. Margerson, I know you've said it, but just for the record.
For the record, I did not agree with the motion for rehearing. As my research into the RSA, the applicable RSA, which is 677, and looking at the board's rules, there is no provision that allows us to entertain a motion for reconsideration for a motion for rehearing. The RSA states that after a motion for rehearing is granted, that it goes to a rehearing. That's the procedure.
Okay. Ms. Eldridge?
I suppose that I will trust, and I have nothing left to add, that this is an accurate rehearing, that this is an accurate, you know what, I agree with everything Beth said, and this is a very confusing situation. But if that's what we can't do, then we can't hear it. We can't follow through on this. We have followed through on this to the degree that we can.
Well, I mean, I want to make it clear that we do go to a rehearing on this application now, because the motion to grant the rehearing was a 3-3 tie, and according to our rules, we are going to a rehearing.
Okay. Anything further, Ms. Eldridge? How about from anyone else? If not, no? Okay. Well, why don't we just take a vote, see whether if we're alternating, we'll start down this side with
Yes,
Miss-
not.
Ms. Marges. Once again, your motion, just so it's perfectly clear to everybody.
The motion is to deny the motion for reconsideration for a motion for rehearing.
Okay, thank you.
So,
Mr. Lee?
I have a question just before
Okay,
you vote.
sure.
So, down below that, in request to postpone the rehearing, what does that do to that if we pass this, if we vote?
Then you'll take that up.
We'll get to that.
That'll be next. That's next on the agenda.
Okay, in that case,
Aye.
Aye, okay. Ms. Eldridge?
Yes, aye.
Ms. Margerson?
Yes.
Yeah,
Yes.
Mr. McDonald? Mr. Mantle?
Aye.
And the board chairman acts, I'm not used to that yet, votes yes also. The motion is carried. Okay. That takes care of the items under old business for the agenda. We'll move to related topic under new business. Item A under new business reads as follows. Request to postpone rehearing of the appeal of Duncan McCallum, attorney for the applicants, of the July 15, 2021 decision of the Planning Board for property located at 53 Green Street, which granted the following. A wetlands conditional use permit under section 10.1017 of the zoning ordinance. B, preliminary and final subdivision approval. And C, site plan review approval. Said property is shown on Assessor Map 119, Lot 2, and lies within the Character District 5, CD5, and Character District 4, CD4. This is a request to postpone LU-21-162. Who would like to open the comment on this?
I'm assuming I'm on this one.
Yes, you are. Thank you. Yes, you are. You want to speak to it?
Well, I guess the question is the attorney here representing the client on the rehearing? Because if they're requesting to postpone, and we don't postpone, we'd have the hearing tonight. So do we have both parties present to even have the rehearing?
I don't know. Good question.
I only see one party here.
So I guess the answer is no.
But in addition, you do not have any materials related to the rehearing. So that was,
Mr. Sis was going to bring that up. That's very relevant, obviously.
I mean, we have a lot of materials on this particular case.
Yeah, that's for sure. No lack of reading. Okay. Anything further on that, or anything further from Ms. Margison?
I think it makes, I mean, the planning, or the legal department, the planning department's suggestion was to continue this for, deal with the motion for rehearing tonight, the motion for reconsideration and motion rehearing, and continue this to next month, or perhaps to its own date next month, and I would agree with that. I think it makes sense to just do this in the next month.
Okay, is that a motion?
No, I'm just saying.
Okay. Okay. Anybody else from this side? Any comments from down?
I mean, I think it's a reasonable request, and
Okay. Any, Mr. Hageman?
Mr. Chair, I move to postpone.
Thank you. Is there a second to that motion?
Second.
Mr. Mannell, thank you. All right, your motion, Mr. Hageman.
Well, given that one of the parties isn't here and we lack the information to actually hear the rehearing on whatever merits are going to be brought forth for the rehearing, I think it's incumbent upon us to postpone, especially since it was deemed appropriate to address the request for reconsideration for the rehearing before we went to the rehearing.
Thank you. All right, Mr. Mannell, your second?
What Mr. Hageman just said.
Okay,
Thank you.
thank you. All right. Moved and seconded. Any further discussion from the board before we take a vote? Any further discussion? No? Okay. Which way did we start voting last time? Did we start down there? I think that is like, it doesn't matter. The motion, just for clarity, is it just
postpone.
once more, please? Just
The motion is to postpone.
postpone, right? Mr. Lee,
Yes.
Mr. Rossi,
yes.
Ms. Eldridge?
She's not
Ms.
voting.
Oh, that's right, you're out, sorry.
We'll do yes
Ms.
and no.
Margison,
Yes.
Mr. McDonald,
Yes.
Mr. Hageman,
Yes.
Mr. Mannell,
Yes.
and the chair votes yes also. The motion is carried. Okay. It is postponed. Okay.
Mr. Chair?
Yes.
Since this is going to be heard at the next hearing, I don't know if we should define the scope of our review upon rehearing, or, when you rehear matters, you can either rehear the whole matter, or you can just limit it to certain topics. I don't know if the board has any thoughts on that. There's new information, and then there's the old information. I haven't been on the BOA long. I'm not sure how you handle a rehearing when you do one with the customers.
Well, they're pretty, the first answer is they're pretty rare, so we don't have a lot of practice and therefore not a lot of precedent. I know what my own preference would be on that, but let's see if there's any other thoughts that might be very useful for everybody involved to make some sort of a definition of scope. Anybody, any thoughts on that? No? How about, did you have a,
Well, I do think that, you know, we have given this application a lot of attention and a lot of hearing time. I would prefer just to limit it to the new information that was presented, which kind of got folded into the replies to the motions for reconsideration, but I think that it would make for a more focused, streamlined review, and that in accordance with, you know, the previous review I assume this will probably go to court, would probably give them enough evidence to go to court with, but I personally would like to focus the review, but there's no right or wrong answer with this one.
no, there isn't, no. My own thought is it might be hard to define what's new, at what point does something become new? Anybody else? Mr. Hageman?
I think it's inevitable that both parties are going to end up retreading some of the prior ground.
Probably impossible to.
I don't know that that's avoidable, even if we were to give a directive on new information. You could always nuance something to have it an appearance of newness that may not actually be accurate. So I don't know that we really should attempt to limit the scope at this point.
Okay.
That's my take on it.
I guess my thought was that it would be very difficult to define what's really new, sort of along the same lines as you've just expressed. So we'll just hope that both parties listening to these comments and take them under advisement.
You could be very judicious with their time.
Yeah. We could. All right. Okay, I'm not going to ask for a vote on that. I hope that discussion will be useful to all parties involved. All right, let's move along here. Item B is a request of Camelli. If I mispronounce your name, please correct me. Development LLC owner for property located at 232 Wybird Street, whereas relief is needed to demolish existing detached garage and construct two-story rear addition with attached garage, which requires the following. 1, a variance from section 10.521 to allow a 6-foot right side yard where 10 feet is required. 2, a variance from section 10.321 to allow a non-conforming building or structure to be expanded, reconstructed, or enlarged without conforming to the requirements of the ordinance. Said property is shown on Assessor Map 149 as Lot 14 and lies in the General Residence A GRA District. Who speaks in favor, please?
Thank you, Mr. Chairman, members of the board. I'm Tim Phoenix from Hopeful Phoenix, Gormley and Roberts here in Portsmouth. I'm here today on behalf of Camelli LLC and Charlie Seafried, the single member of Camelli who has bought and is trying to renovate this property. Also with me tonight is Joseph Wentworth from Market Square Architects, who has prepared the architectural drawings. Peter, if you could go to A2, the first page of A2. So what we have is an 11,785 square foot lot, which holds a small 2 or 3 bedroom single-family home with a large detached garage. The existing home slightly violates the front setback. The existing home a little more greatly violates the right side setback, and the garage is about 1 foot from the sideline. As you can see on the plan here, this is the proposed conditions plan, and you can see the lower property line, which is the right side property line, and just that little sliver is what needs a variance. And the reason it needs a variance is because although the existing home, as well as the detached garage, is closer yet to the lot line, the renovation is calling for an addition on the right side that's not as close to the lot line as existing, but it's going up 2 stories. Peter, if you can go to, there's a page that has the new superimposed over the old. Yeah, it's probably 5 or 6 pages in. There's a chart at the top left of it. Wrong way. Go the other way. Nope.
The site plan or floor plan?
They're kind of mixed together, but it's a floor plan. There you go, right there.
Okay.
So this page, and it's in your packet, shows the new superimposed over the old, and you can see at the lower, on the lower section to the left, there's an arrow showing existing conditions, and that's what's coming off, and the white is what's going on. And to the rear of that, on the lot, you'll see that very large garage, which is very significantly encroaching upon the right side setback. That is coming down altogether, and you can see the rear addition, which goes over and connects to the large square at the top of the page, which is a garage with living space over it. Before I move on any further, I'd like to give the board, I only have one of these, but this is a letter of support from Alex Hussein, who's at 222 Wyverd Street and is the neighbor that is next to where the addition is going. So he's on the lot below that lot. If I may turn that into the chair?
Yeah.
The other thing I'd like to mention before I move on is Peter Stith contacted me a few days ago with an email from the neighbor to the other side, who is Dr. Gray. And Dr. Gray didn't seem to have a problem with the overall concept, but he had primarily an issue with windows on that second floor that are facing his yard and would, as he put it, decrease his privacy. So what we've done, if I may have Joseph come up, we've got a replacement set of plans that what we've done is those windows will be frosted. And the replacement set of plans, I'll give you a minute to see them.
Thank you.
So while you've got those, if you turn to page A 1.0, A 1.01, which obviously Peter doesn't have, but if you look at that, if you find that page, A 1.01, at the top right, you'll see 4 arrows, and in those arrows it says frosted. So that's indicating our commitment to frost that glass. And then if you then find page A 2.00, you'll see the elevations of the back of the house, or that side of the garage, if you will, and that's at the top left of the page, which also says frosted. So we are asking, in order to address Dr. Gray's concerns, that you, assuming you do grant this, that you grant this conditioned upon those windows on that second floor being frosted. So it's easy to see what we're doing. Peter, if you can go to the photographs, which is Exhibit B, and it's like the 6th or 7th page in, there's a photograph of one side of the house. Looks like it's going to be sideways. Keep going. It shows a glass sunroom type of a thing is what I'm looking for. One more. Keep going. So right there, that's a photograph of the house, and you have photographs of the house and a rendering of what it's going to look like. So that little addition on the back and that little sunroom, that's what's coming off. And approximately where the door is, that's the depth that the new addition will be, which will be about 6 feet from the lot line, where the closest portion now is probably 4 feet, 3 or 4 feet, and the garage is 1 foot. So we need relief because a 785 square foot portion of the new addition and expanded second floor violates the setback, and it's because of the expansion going up. But right now, there's 1,273 square feet of violation in that right side setback. And as you know, because you haven't all seen it, but I just gave a letter that from the abutter that's facing it, that he has no problems with it, and I trust that the doctor will be satisfied with it since the glass will be frosted and he won't be able to see into his yard. So with that, the variance requirements, we always talk about the first two together. The variances are not contrary to the public interest, and the spirit of the ordinance is observed. And the underlying test is whether granting the variance would unduly and to a marked degree conflict with the ordinance such that it violates the ordinance's basic zoning objectives. And the case law tells us to do that, we ask, does the variance alter the essential character of the locality or threaten the public's health, safety, or welfare? Well, this variance will benefit the character of the locality because it will be a less non-conforming home on this lot. It will be much more beautiful. It will be brought up to code. The neighbor who's most affected by it supports it. So being brought up to code and being further from the lot line than existing conditions, both the essential character of the locality and public health, safety, and welfare are protected. The third of the 5 requirements is granting the variance will not diminish surrounding property values. As the rendering shows in the set of photographs, this is going to be much more beautiful. It's going to have an attached garage with other space. The neighbors who are affected by it, seemingly, one of them specifically approves it, the other with the frosted glass, we trust they would approve of it. But it's clear that these changes will better the property and therefore will not diminish property values. The fourth of the 5 tests is the hardship. The first test is special conditions. Clearly, we have a lot which only has, I think, 60 feet of frontage. The house is already there. It already violates the front and right side setback. If you're going to add to the house, the only place you can add to the house is where it is. So those create special conditions that allow this board to consider granting this variance. And we think that although we're going up 2 stories to make the house more livable, it's primarily about hallway width. This is a much better project or home than it is today. And there's hold on one second. These create special conditions that should permit this very slight sliver variance, as you can see again on A2 at the bottom, with the more significant violations being removed. Now, the second prong is no fair and substantial relationship exists between the purposes of the ordinance and its application. Setback requirements, why do we have them? To create air, light, separation from neighbors, area for stormwater to be treated as it comes off the roof, et cetera. So we're making things better in all respects here, so therefore there's no reason to apply the strict requirements of the ordinance. Third prong is the proposed use is reasonable. The case law says if the use is permitted, it's reasonable, it's a residential use. And finally, substantial justice will be done, and the tests under the case law are if there's no benefit to the public that would outweigh the hardship to the applicant, this factor is satisfied. Or any loss to the applicant not outweighed by a gain to the general public is an injustice. And we think it's pretty clear here that there's no benefit to the public from denying these variances. The only affected neighbor, primarily affected neighbor, supports it. Yet the loss to Charlie and his company to redevelop it and sell it to some nice family here in Portsmouth, he will lose the ability to develop it the way he sees fit. And since it's such a slight variance to begin with, we think it is substantially just to grant the variance and would be unjust to deny it. That's all I have. I don't know if either of my guys have anything they want to add. They're shaking their heads no.
Mr. Hageman.
I think I'm sitting this one out as a voting member, but I get to ask questions.
Darn.
They're easy. The new plans with the frosted glass reference, are those going to be filed with the city? Like how, in terms of
However, I take Peter's guidance that whether what we've given is sufficient or he wants something formal with a cover letter, I'm happy to do it.
I only ask because I don't know if it's, for the members who are voting and motioning eventually, if it's worth any kind of stipulation, since that was a concession being made for an abutter. Just
Sure.
that.
Right, if you make it a stipulation, I mean, these will be in the file, And you just
We
have to-
take things as presented, I get that,
Right,
it's just,
right, but
sometimes
unless you
plans
stipulate-
change.
That's true.
That's why I had originally suggested to Joseph that we just give you those 2 pages, but he thought, and I was convinced, it's simpler to just give you the whole exhibit, and that this will replace Exhibit A.
Just to state the obvious, the F is only shown on one pane. It means the whole window.
Yes,
Correct,
yes, it
okay.
does.
Thank you.
Yeah, on the plan, it just says F.
Right.
So
I
it's
noticed that.
the whole thing.
I have a question.
Mr. Lee?
Would these frosted windows be operable? Do they go up and down?
I think they're double-hung windows, aren't they? So, yeah, I mean, you can open them and close
There's
them.
the possibility of somebody opening the window and sneaking a peek at the good doctor?
No, I suppose, it could happen from time to time, but we'll tell them they can only open it from the top or something, I don't know.
All right, thank you.
only during certain hours.
You gotta
of the
make
day.
me work, Jim, I don't know.
I'm just messing with you.
You only use those windows from 3 to 4?
Exactly. Only at night, how's that
Yeah,
sound?
exactly, AM, in the winter.
Anything else from the board for the presenter? Anything else at this point? No, apparently not. Thank you very much.
Thank you.
Is there anyone else present who would like to speak in favor of this proposal? Anyone else in favor? Anyone else opposed? Any opposed? Seeing nobody, do we have anybody on
Oh, wait,
Zoom?
hold on. Thank you. Let me see. Yes, David Gray, let me,
Yes, hello, and can you hear me? Sorry, we're in our home on Zoom.
yes, we can hear you.
Okay, wonderful. Thank you, Mr. Stith, zoning board members, and the attorney who spoke. We're not opposed to the project, but I just wanted to clarify a few items. So as we look at the plan, and just to draw your attention to the garage space, second floor, there are some items that we notice: a bathroom, a refrigerator, a kitchenette. So it has the look of an apartment. Now, in a communication with Mr. Seafried, we understand that he is not seeking approval for this to be an accessory dwelling unit. And I just hope that the minutes of this meeting reflect that, that this structure is not being constructed with that as the intended use, such that if it comes before the board in the future, that has been documented.
Peter, yeah, that's the right page, 1.01.
Yes.
Yeah, here's the image of that. It is not intended to be an ADU. Charlie has no intention of coming forward to make it an ADU. What it is there is a shower. It's basically a rumpus room, game room, so to speak. And what you see in the lower right of it is a little wash sink, a small dishwasher, primarily for doing beer glasses and the like, and a small apartment style, not a full size refrigerator. So it's just a place for family members to go. It's not a place for nobody's going to live in that room. Nobody's going to. They're not going to rent it out to anybody. It's just intended to be a room to go to hang out, watch a movie, have a gathering, that kind of thing.
Okay, that sounds pretty clear to me. Thank you. The other, sorry, this is obviously our first time attending this meeting. So could you just clarify the bit about the frosted glass, and if that remains in perpetuity for the approval of this building, such that if the new owner desires unfrosted glass, are they able to remove those, or is that a permanent fixture in this home, if you will?
Doctor, this is Tim Phoenix responding to your question, counsel. Typically, variances, once they're approved, and if they're approved as presented with plans, that's a permanent item. Somebody couldn't go and change that without coming back to this board and requesting that change.
Okay, that's wonderful. I appreciate that. Thank you. I have no other questions or comments, and I want to echo what's already been said. It does look like it's going to be a beautiful home, and we want to thank Mr. Seafried for endeavoring to do this.
Thank you.
Thank you. Anything further, Mr. Stith, on, and just for the record, that the speaker was the immediate neighbor, adjacent neighbor?
Correct. No other hands have been raised.
Okay. Anything else from the board on the, okay. That, excuse me. And we've all gone, any other speakers? Last call, 2, 4, or against? Anybody at all? Apparently not. Okay, we'll close the public hearing. Excuse me. Ms. Eldridge, you know you're in on this one.
Yes, thank you.
Is there a motion, please, from somebody? Mr. McDonald?
I will move to approve this application as published.
Thank you. Any second to that motion?
I'll second.
Ms. Murchison, thank you. Mr. McDonald, your motion.
My motion is to approve the application presented in the attached documentation for the reasons that Mr. Phoenix went through in assessing the tests that variances must pass. And I think they've done a good job of that. But the thing that clinched my mind is when I drove by to look at the property, stopped, got out, and walked in and walked around a little bit. It's very clear that if somebody doesn't do something to improve the property, it's going to fall down. So it's definitely in the public interest to see this project proceed, and there are no objections. I haven't heard anybody objecting to the project, so I'm in favor of it and say we should approve it.
Thank you very much. Ms. Murchison?
My second would be that in terms of the variance criteria, the variances will not be contrary to the public interest. The spirit of the ordinance is observed. While this is still, the variance request is still beyond, instead of 6 feet, instead of 1 feet, 10 feet, we have 6 feet. The reality is that it is, brings the property more into conformance with the existing zoning ordinance. And so therefore, I find that the spirit and intent of the ordinance is satisfied. It will not diminish surrounding property values. Any renovation or update to a home certainly increases property values next to it. And that I do believe that there is, it would be an unnecessary hardship to the client. There is no loss to the public that actually outweighs the, I'm sorry, I think I got that separate. Benefit, yes. So for those reasons, I second if I've made them right, I second the motion.
Thank you very much. Anything further from anybody on the board?
Can I just clarify that there is no stipulation for frosted
It was
glass?
in the, inherent in the, as the attorney spread, is
Okay.
inherent in the, and it's recorded in the deliberations if you,
Well, I
But
think
it'd
that,
probably be-
I think that Mr. McDonald did say that it was as presented. That's why
Right. I thought
Mr.
that was
Mulligan
part of it,
always
yeah.
used to say presented and advertised.
yeah.
So it's upon these
Does anybody else
drawings.
feel strongly that we should attach a stipulation to it? No? Okay, all right. That being the case and no further comment, we'll go to the vote. The vote is to approve as presented with the understanding of the frosted window requirement. Let's start down here. Mr. Mantle?
Yes.
Mr. Hageman? No? Mr. McDonald?
Yes.
All right. Ms. Margison?
Yes.
Ms. Eldridge?
Yes.
Mr. Rossi?
Yes.
And Mr. Lee?
Yes.
And the chairman votes yes also. The motion is carried. You're welcome. Project is approved. Okay. Okay, moving on to item C under new business. A request of, and again, if I butcher these names, please correct me. Request of Sherbeth Young and Joseph DeBella, owners, for the property located at 0 Woodbury Avenue, whereas relief is needed from the zoning ordinance to construct a single-family home which requires the following. 1, variances from section 10.521 to allow A, a lot area of 7,436 square feet where 15,000 square feet is required. B, a lot area per dwelling unit of 7,436 square feet where 15,000 square feet is required. And C, 60 feet of continuous street frontage where 100 feet is required. Said property is shown on Assessor Map 220 as Lot 16-1 and lies within the Single Residence B SRB district. Who speaks in favor, please?
Thank you, Mr. Chairman, members of the board, Attorney Derek Durbin for the record. I'm here on behalf of Dr. Beth Young and Joseph DeBella, the owners of the property, which doesn't currently have a street address. The property is a vacant parcel of land located off of Woodbury Avenue. It's just a little bit north of the I-95 overpass and Rockingham Avenue on the right side of Woodbury Avenue if you're coming from essentially downtown or from the Holiday Inn. The property was one of two involuntarily merged parcels that was restored to its pre-merger status by the City Council in 2018. Beth and Joseph purchased the property in 2021 with the intent of constructing a modest single-family home on the property. As proposed, would be 2 stories, have 3 beds, 3 bedrooms, 1.5 baths. Would serve as their primary residence. If you're wondering about finished square footage, I'm looking at the plans, it's about approximately 1,806 finished square feet of living space. So it is pretty modest-sized home. The property is non-conforming with respect to lot area with 7,436 square feet, and it has continuous street frontage of 60 feet where 100 feet is required in the SRB zoning district. Otherwise, the proposed home will meet the setback requirements of the ordinance. It will meet the building coverage requirement and the open space requirement. Because the property does not conform to lot area and continuous street frontage, it's the city's position that the applicant must obtain 3 variances. They're all interrelated to address these deficiencies. We do disagree respectfully with the city that a lot area variance is needed. We've applied for lot area per dwelling unit, and continuous street frontage. We don't disagree that lot area per dwelling unit and continuous street frontage variants are needed. We do disagree that lot area is required, given the fact that the City Council did restore what was a non-conforming lot of record back to its pre-merger status. It didn't cure the deficiencies of trying to develop that property and any relief related to that, but it is our opinion that it did cure the lot area deficiency. So as lawyers like to say, we've applied for the lot area variance, the 3rd variance, out of an abundance of caution. Unless there are questions by the board at this time, I'd simply turn to the variance criteria. Seeing none, granting the variances will not be contrary to the public interest, will observe the spirit of the ordinance. The property is non-conforming lot of record that predates current zoning. The property does have adequate street frontage to provide for safe ingress and egress. As I pointed out, the applicants will be constructing a home that will meet the other requirements of the ordinance, particularly setback, building coverage, and open space height requirements. Therefore, it will not negatively impact the light, air, and space of abutting properties and the homes and structures thereon. The proposed home will comply with current life safety and building codes, will not create any undue demand upon municipal services. Therefore, it will not threaten the public health, safety, or welfare. There are many examples of similar sized lots in the SRB zoning district, particularly in this area of Portsmouth. Many of them, if you were to do a calculation, are in that sort of like 6,000 to 10,000 square foot range. This is, I think, overall a minimal request for relief when you consider the small size of the lot and the narrow building envelope that the applicants are working with, which they have configured the home into, and the access. Substantial justice will be done by granting the variances. There would be really no gain to the public in denying them. There would be a hardship, rather significant financial hardship on the applicants. However, if the board were to deny the variances, not be able to build a modest single-family home on the property. So therefore, under the circumstances, I would submit to the board that the equitable balancing test for determining whether substantial justice is done weighs in favor of the applicants. The values of surrounding properties will not be diminished by granting the variances. overall. And as I think you can see from the elevations that were submitted with the application, they're going to construct a pretty tastefully designed home. They have engaged an architect, and it will serve as their primary residence. There's not really any evidence to suggest that, to the contrary, that this would negatively impact surrounding property values. And I would argue to the contrary of that, that there's plenty of evidence throughout Portsmouth, similar examples and variances granted, that this is likely to improve surrounding property values. Literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. Again, as a vacant, non-conforming lot of record that was involuntarily merged with a neighboring lot many, many years ago, and was restored to its pre-merger status in 2018. That is a unique condition. It's also quite small, even when compared to some of the immediately surrounding properties, many of which still fail to conform to the 15,000 square foot lot area requirement. Owing to these special conditions of the property, therefore, there is no fair and substantial relationship between the general purpose of the ordinance provisions and their application here. The use of the property for a single-family residential use is permitted and encouraged within the SRB zoning district. Therefore, the use is reasonable. So in conclusion, I would submit to the board that the application meets the 5 criteria for granting each of the 3 variances requested tonight, and hope that you will find the same. I'm happy to answer any questions you have. I have Dr. Young and her husband, Joseph DeBella, with me as well, seated in the back row behind me, who are here and can answer any questions you might have as well.
Thank you. Any questions? Mr. Hageman?
Thank you, Mr. Chair. So am I reading the plans correctly that there's going to be a garage underneath the house?
That's correct.
So the lot appears to be a pretty flat lot. Are you significantly altering elevation around the house or beside the house in order to get a driveway down far enough to enter a drive under the house?
This will come down a little bit. The property does slope down, as I understand it, and as I recall from the abutter to the right, the abutting property to the right. It does slope down a little bit. The terrain will not be altered significantly to make this happen. This was the easiest way to get a garage in that wouldn't take away basically the backyard space, and also for access in and out of the property. This was the configuration that worked the best. There will be a drainage basin. I'm not sure exactly what the engineering is behind that, to be honest, but there would be a basin installed to deal with any of the on-lot drainage. It wouldn't flow onto the neighboring property to the right because it's a higher elevation, but to deal with stormwater from the creation of that depression there.
Okay, I think you answered what would have been my
Yeah.
follow-up in that you're
Okay.
basically managing runoff because
Yes.
you're angling back towards the property that you're building.
Yeah, there was a lot of thought given to that. At least there was a discussion between Ambit Engineering, who's the engineer, and the designer, the architects, which was Benchmark on that particular subject. And this actually, the plan went through several iterations to come up with this particular design.
And just one final question, Mr. Chair.
Yes, please.
I'm assuming, since the engineering was behind this, but there's plenty of room to back up, get in and out without.
Yes.
Okay.
Yes, absolutely. And
Good question.
yeah, I actually had one thing I wanted to point out, which I failed to in my introduction, was that you'll see a temporary shed on the plan that's close to the rear abutting property line. That is something that has existed there and is dilapidated, falling over. That will be removed. And I just want to state that as a representation of the board, that we are not seeking setback relief for that. That is a structure that will be taken off of the property. It was there when my clients acquired the property.
Any questions on this side? Anybody? No?
When your clients purchased the property, what kind of diligence did they do to assure themselves that it would indeed be a buildable lot?
I think the due diligence that they did was looking at the city council approvals, as I recall, the city council approval that went into restoring it to its pre-merger status, so review of the municipal records associated with the property to make sure that it is, I mean, obviously it needs relief before this board, but to ensure that should the relief be granted by this board, that it would be buildable. there's no automatic right to building on a lot like this because of zoning, but I would say that there are some the rights that go along with the property from the predecessor owners on.
Mr. Hageman?
Sorry,
No
repeat
problem.
offender. There are a lot of letters that came in relative to this application, and several of them mention the underlying purpose of originally separating the lot being to discourage future development as opposed to encourage it, and then apparently some indication that future real estate agents might have to say to a future buyer, this is a non-buildable lot. Do you have any background information on that, or anything you can provide in terms of context, or?
That's the first I've heard of it. It was listed publicly. It was marketed and listed. I don't know if it was as a buildable lot, but it was listed as a lot of record, as restored to its pre-merger status. I had another client that had, I don't know if they ended up submitting an offer, but they were interested in it. I think everybody viewed it as a buildable lot per se. Subject to obviously needing the variances, but yeah.
Okay. Thank you.
Yeah.
Thank you. Anything on this?
There are no deed restrictions, I should point out, that would make it non-buildable.
There are not.
Yeah, there are no deed restrictions, yes.
Yeah, it's good. It is a registered lot.
That's
right?
correct,
Okay.
yes. It was, it's always been described as a separate lot, yeah.
Okay. I guess my other how long ago, it maybe say it in here, I don't recall, how long ago, what was that city council action?
The city council action was in 2018.
18? Oh, so
Yes.
fairly recently. So,
Fairly recent.
Yeah.
Yeah, I think everybody was trying to get those requests in because it was set to expire in December. You had to make your request by December of 2021. I actually think that got taken out by the legislature in September. I could be wrong. But I looked back at it the other day because I saw one in my neighborhood, and I didn't see the 2021 in there. So maybe it'll slow down a little bit. But yeah, I think this was part of that surge, in the last 3 years to get them all in.
oh, okay, thank you. Ms. Margison?
So this doesn't have a property address yet. Is there a process for doing that? For instance, does this have to go through TAC or planning board, or what will have to happen for it to get a street address?
Yeah, my understanding is that if it is approved by the zoning board here, the variances that we're requesting, it wouldn't need to go through the planning board since it's not a subdivision. Then it would go to probably Public Works, I think.
Right.
It's
Public
yeah, that's
Works.
correct.
Public Works
The
will do
GIS
it.
department.
Yeah,
They work
and
with the
Jamie
sign.
McCarthy, I think,
Yep.
is the one that
Okay.
sorts that out.
Okay. Any other questions from the board at this point?
It's a question.
Yes, Mr.
Just a
Yes, Mr. Rossi.
clarification. Does the fact that it's listed as a lot, does that just relegate the previous statements that apparently were made that it was not intended to be developed when it was redivided?
I
Does
don't
that
think
make
those
them
statements are
irrelevant?
binding.
Okay,
in any
so those
manner,
are
no.
non-binding.
Okay. Anything else at this point from anybody on the board? No? Thank you very much.
Thank you.
Anyone else present who'd like to speak in favor of this proposal? Anyone in favor? Seeing anyone on the Zoom situation?
There are, but no one is raising their hand in favor.
Okay, all right. Okay. Is there anyone present in the hall who'd like to speak in opposition to this proposal? Anybody in opposition? Yes, please come up, make a line if you want, or just come right up. Your name and address, please?
Sure. My name is Ann Perkins, and I live at 759 Woodbury Avenue. For reference, I am on the same side of the street as 0 Woodbury Avenue. There is one house between us, so 759. And additionally, when you're in my backyard, you can see that property. It's 100% within the sight line. But I'm here tonight to publicly state that I am not in favor of granting any of the variances for the non-conforming lot at 0 Woodbury Avenue. The applicants want to wind back the clock to earlier times when zoning laws were different here in Portsmouth. At some point, the laws were changed and updated to address the needs of the community. So I really don't see the need to grant a variance for them. And we're not quibbling over a small amount of square footage, say 1,000 or 1,000 square feet or a little bit more. Honestly, I wouldn't probably have a problem with that. But really, it's practically half of what a conforming lot should be in 2022 in Portsmouth. That is incredibly significant to me. And as you discussed, as we just, was discussed with the history of the lot, it was subdivided and intended to be a non-buildable lot. So I find it just so ironic that 2 years ago or 3 years ago, it was supposed to be away from property developers, and now fast forward, there's going to be something built on it, or potentially. I just don't, it doesn't make any sense. Also, there was a reference to the financial hardship. I feel a little strange saying this, but honestly, I'm not sure that's relevant. When you buy a property, it's up to you to do the due diligence and the homework, and it probably would have been better for them to do all the front end approvals on the front end, because asking for a variance is really important. It sets precedences that are really hard to get away from, and it could create a lot of future headaches for other properties in my neighborhood, the city, before this board. So just to summarize, I'm not in favor of it, and my hope is that the variances are not granted. Thank you for your time.
Thank you. Next speaker.
Yes, Edward Baldessari, 717 Woodbury Avenue, and I live right next door to this property. And when property is sold like this without a contingency, you take a risk in buying something that has no approval. And so I don't know why you would do that, risk your finances in that manner. The other problem is, which was just said, it's less than half the square feet of a building lot, 60 feet of road frontage instead of 100 feet of road frontage. That leaves 40 feet left for road cuts, gas, sewer, water lines, driveway, and there's a utility pole right there by where the proposed driveway. The proposed driveway would be right on my property line. In other words, there's absolutely no space between my property line and where that driveway is going. So the other problem that I see is stormwater runoff problems. We've had them in the past, and even though I do have a picture of what happens, and if I can show you that, or present it.
If you start it down at that end, please.
Pardon?
Start it down that end, please.
So this is what happens when you have stormwater, and I'm right
No, I need you to talk to the microphone, please.
Okay. So that's what you see when you have stormwater come through, and it's not taken care of.
Now, for reference, that's the back of your house.
That's the back of my house, right.
And you're the Cape. And if I'm
To the
looking
right.
at your house, on the left-hand side is the church parking lot. On the right-hand side is the lot in question.
Actually, if you face my house, that lot is right to the left of my house. If you face
To
my
the left
Cape.
of your house.
Yep.
But if
Right
I'm
to-
looking at your house, it's on the right.
My house is to the right of that lot.
Okay.
Okay. So I see stormwater runoff problems there, and I think that's about it. I think I covered it. But anyway, the driveway issue is, I don't know if that's allowed to have no space between properties, put a driveway in. And then with everything else in mind, the ball's in your park. Okay, thank you very much.
Thank you.
Okay.
Next speaker, please.
My name is David Perkins. I live at 759 Woodbury Avenue, 2 houses up from the lot. It's requesting the variances. I just want to make a couple of points in the variance criteria that were made. So you talk about safe ingress and egress. Well, we know from past experience, when cars are parked outside on the edge of that lot, it blocks the vision from people coming out of their driveways and creates a safety hazard. It's been reported to the police in the past. That's one. And there are other similar size lots in the area. Well, there are on Woodbury Avenue because the houses were built in the early 1900s before the zoning laws existed, including my house, which was built in 1937. And basically, we're talking about the ordinance protecting our green space in our neighborhood. When you shrink the lot size down in a variance, you take away that important green space that we like in our neighborhood. So please consider that. Thank you.
Thank you. Next speaker, please.
Hi, my name is Stacy Schmidt. I live at 690 Woodbury Avenue.
Could you speak right into the mic, please? Pull it towards you a little bit, please. Yeah, so we can hear you better. Yes. Thank you.
Can you hear me better?
Yes, that's better. Thank you.
So, Stacy Schmidt, I live at 690 Woodbury Avenue, directly across from this property. And I'm going to try not to be too redundant, but I do agree that a majority of the homes on Woodbury Avenue are closer to the 15,000 square foot requirements, with an exception of some of those that were built long before the ordinances were in place for the city of Portsmouth. And granting this variance affects our natural barriers significantly. 2 full-grown Japanese maples were already removed from the property. This property is at a lower elevation from the church, the Corpus Christi Church, where there's a natural pond, and the grade goes down Woodbury Avenue. There have been significant structures on Maplewood as well as Rockingham where they have overdeveloped the areas, and there have been significant flooding, which they've had to address after those buildings were erected. This is not personal, but I completely agree. This lot was separated under the pretense that it was not to be used as a buildable lot. In its pre-existing condition, that was what the prior owner had brought before the board. That was the purpose for its approval, and that it was to provide green space. She was going to use it for gardening. She had sold the other portion, and it was not to be built upon. That was set in place. Had any of us been aware that this was going to be the potential in the future, then we would have opposed the separation of taking those lots apart. I believe a majority of what else I had on here has already been addressed. But I personally emailed the listing agent prior to the sale of this property to inform her of why this lot was taken from its original, why it became non-conforming. And that it was to keep it out of the hands of builders, and that there was no intention for it to be developed. That's all I have. Thank you.
Excuse me. Last call for speakers, 2, 4, or against. Last spell.
We have some
I'm sorry.
speakers on the Zoom.
Oh, we do. Okay, Zoom. Good.
Catherine Auger Campbell. Go ahead.
Excellent. Thank you so much. Catherine Auger Campbell. I live at 75 Ruby Road, so I am a direct abutter on the backside of this particular piece of property. I submit one of the letters that you likely have there. I am not in favor of granting these variances. I think, even just the clearing of the land, which was done, without any consideration of neighbors or consideration of, getting a variance, was a little bit of a cart before the horse scenario. But, even doing that significantly impacted the properties that abutted this, and removed really any semblance of privacy that any of our lots had here on the backside. Certainly understanding that green space is a priority here. I'm sure none of you are surprised to hear about the concerns that we have for noise. Those have been going before the board as we've worked, really hard with the state to try and get some sound barriers. But the removal of those trees, even the construction piece here is a significant impact to our ability to enjoy the properties that we purchased. All of us purchased our land, with this particular piece of land set as it was, with no expectation that an additional lot property would be put in and built upon. It has a significant impact on our ability to enjoy, the properties that we have all purchased and spent a lot of time and effort into developing as part of our homes.
Are you all set?
Thank you. Yep.
Thank you very much. Anyone
Yes.
else, Mr. Stiff?
Steven Rodriguez.
All right, can you guys hear me okay here?
Yes.
All right, well, first off, thank you all for making Zoom available for the community, especially in the age of a global pandemic here, so very much appreciate that. So sort of the comment that I have is just regarding page 2 of the variance relief application.
Excuse me, your address, please, Mr. Rodriguez?
Sorry, say that again?
Your address, please?
737 Woodbury Ave. Mine is the address that was unmerged back in 2017, though I was not the property owner at the time.
Okay, thank you.
Yeah, absolutely. So, my question's more in regarding page 2 of the variance relief application, specifically the notes on significant, injustice to deny the right to build. There's been a few notes just regarding sort of the due diligence that went into the effort and this being, returned to its pre-merger status. I think sort of my concern and confusion is sort of regarding the purpose for it being unmerged as a lot, and that was to keep it sort of out of the hands of developers. So I think part of what we're hearing here from the community is some confusion, right, or around the last board meeting that was done in 2017 to unmerge the lot, with that context and use case in mind. Just to sort of return to this conversation today, I wasn't a member of the community at the time, but I am familiar with the case. In terms of significant injustice, it's my understanding that the real estate company had been provided with those meeting minutes in the history of the lot. So I do just generally have some questions regarding whether that information was passed along to the purchasers or to Durbin Law Office, and how that pertains to the significant injustice around the right to build.
Okay, have anything else?
No,
Okay.
that's it. I'm just
Okay.
trying to square the circle on that one as I'm reading through this.
Okay, thank you for calling in. Anything else, Mr. Stiff?
Anyone else on the Zoom call would like to speak? Please raise your hand. I don't see any.
Okay. In that case, last call, 2 for or against.
Mr. Chairman, again, for the record, Derek Durbin for the applicants. Just to address some of the concerns expressed by the abutters, which I think are natural concerns anytime that you have a vacant lot like this, and I can appreciate. I don't know what representations may have been made, back in 2017, 2018 in the City Council. What I do know is that the City Council does not act based on representations as to whether or not to unmerge a lot. It works on the evidence that the city has on file, including assessing records and what have you, as to whether or not this was a pre-existing lot of record. It is, chain of title shows that. That was confirmed by the City Council and approved after it goes through the planning board process for a recommendation to the City Council. The assessor also makes a recommendation to the City Council as well. It was determined that this was a lot of record, presumably a buildable lot of record, that the predecessor owners had building rights in. Now, I don't know how the owner at that time was intending to use it. I've heard it was intending to use it as a garden, some other things. But I can tell you from reviewing the chain of title that there is no restriction on the buildability of the lot, nor can I see that there was ever any intention regarding that, and I think that's evidenced by the fact that it was marketed to the public and sold without any restriction on it. I understand the sentiment about wanting to maintain green space, but if you were to look at the GIS image I provided the board as part of the packet, I don't know, Peter, you can pull that up, just of the surrounding area. The lots are different shapes and sizes and what have you, but I think the prevailing trend that you'll see in this particular area of Portsmouth is that, and I've done the research because I've sought relief before for other properties within this general area, is that there are not a lot of lots that do actually comply with the 15,000 square foot requirement, whether they're square, rectangular. Many of them are significantly under that. I don't know what the exact average is, but this is closer to the average than you would find any lots that are 15,000 square feet or greater. This is the prevailing trend. It is the character of this particular area. I know there are concerns about the trees removed. I know that's kind of outside the purview of this board. I'd address it anyway. There were a couple diseased trees that were determined by an arborist to be a threat to not only one another, but any other vegetation on the property that were removed. There is no setback for driveways, and that was a configuration that maintained the most open space actually on the property to place the driveway where it is. It also created the best manner for turning into a garage on the property, accessing, getting in and out of the property. A driveway inherently eliminates any issue that the neighbors have had with parking on the street. I'll admit, when I took the pictures, I parked on the street right there. Probably shouldn't have. But a driveway eliminates that because people will inherently pull into the driveway and not park on the street there. So I think that issue's actually alleviated. So I can understand the abutters' concerns. You're taking a space that they've been able to enjoy for their view shed and other reasons, and you're building on it and creating additional density for the area. But I think this is what the spirit and the intent of the ordinance really is for the SRB zoning district in this particular area. So with that, I would just conclude my comments unless I see Chase has a question for me.
Mr. Chair, can I ask a quick question?
Yes, certainly.
Attorney Durbin, it was referenced in one of the letters that there was an agreement to not cut down trees on the property. Is that actually true?
Yeah, we're not aware of any agreement. I know my clients wouldn't be aware of any of that. It would have predated their time.
Okay.
So,
Sorry. So your clients didn't buy from Mrs. Rayburn. It was a subsequent owner between?
No, I don't remember the prior owner's name. So they did purchase from Rayburn, and yeah, as I said, the trees were determined by the person that assessed them to be diseased. So,
okay, thank you.
That's it. Yep, thank you. Any questions on this side? Anybody at all? At all? Last call, very last call for speakers before we close the public hearing. Zoom clear?
Zoom clear.
Okay.
Oh.
No. Last call for real. No speakers? Yes, come up, please.
Last call for real.
You're just under the wire.
The wire's good. I'm going to get him a bigger hammer.
So Edward Baldessari, 717 Woodbury Avenue. I just wanted to point out, in 2019, the board denied approval on a lot across the street with more square feet, actually 10,000 square feet and 85 feet of street frontage, with storm water runoff problems. They denied that lot. The lot was much bigger, much flatter, but it had stormwater problems. And you can look into that one, but that's a fact, 2019.
Right.
Okay?
While you're here, I have a question. You or someone else, at least on this side, has made the statement several times that we were under the impression that this was a non-buildable lot. What was the source of that impression?
Okay, here's the situation. Lynn Rayburn bought the original house at auction. And then she, cut to the chase, she sold it. But before she sold the house, she subdivided the lot with saying that she would be gardening there. She likes farming, and she was going to use it for gardening. It would never be developed. So that was her premise. So a few years later, she decides to put it up for sale during a period of the pandemic, and the property values are going crazy, and there's no lots left in Portsmouth. I mean, it's a frenzy of people buying, as you all know. And when this lot came up, there were many people that wanted it, bidding on it, and which creates a situation where you panic buy without going through the proper procedure to protect your investment. So that I would not buy a lot like that without contingency upon approval. That's the proper way to do it. And so I think the buyer took a risk here, knowingly bought this lot, risking their money, knowing that maybe they won't get approval. And that is something that you really shouldn't do.
Okay, thank you very much.
Right? Is that pretty clear?
Thank you. Yes.
I have a question, Mr.
Yes,
Chair.
I'm sorry. Another question. I'm sorry. Beth, yeah.
So I've heard the word subdivided used a lot. When you say subdivided, do you mean about the merger?
Well, the property was one property. And I guess years ago, it was two properties. So they brought it back to two properties.
So that was so it was involuntarily merged.
Right.
And then it was unmerged through the city council
Unmerged through
action.
the city.
That's not a subdivision.
Right, okay.
So I want to make
Okay.
clear, and I understand your butters and you're upset.
Yeah,
but
yeah.
It's a difference between, I just was trying to clarify if this
Merged
was
and,
ever
yeah.
subdivided.
Yeah.
And, but it was just merged because it was an involuntary merger.
Okay.
I mean, I think that the lot was deemed perhaps unbuildable because it did not comply with the zoning ordinance, but not unbuildable per se. It was just that it was contingent on approval of the variances. I do think that the owners did state that they were aware of that when they actually purchased the lot.
Yeah, okay.
So,
All right.
that's all.
Any other questions?
Thank you, yes. No, that's it. Anybody else? Yeah, yes, please come up.
David Perkins, 759 Woodbury Avenue. So we heard discussion about whether or not this is a lot. No one's disagreeing that it's not a lot. What we're really concerned about, and then all the neighbors, and you've heard from a lot of them, is preserving the ordinances and protecting our green space. It's not going to create a hardship. We've heard about questions about doing due diligence. A lot of us have been there for a very long time. We purchased our properties based on preserving those ordinances, and we asked the board to please consider continuing to preserve those ordinances in your decision.
Thank you. Yes, please come up.
Again, Stacy Schmidt, 690 Woodbury Ave. In reference to Ms. Margison, who, yes, we kept mentioning, the subdivision. I suspect that this land was merged originally due to the extremely small lot size. So it was involuntarily merged. And under Ms. Rayburn's pretense, or what she had planned for the land, it was then unmerged in front of the planning board, as she expressed when she was here, for a non-buildable purpose. It was to just remain green space. And when you're as close as we all are to I-95 and all of its pollutants, and the Eversource cut through from Maplewood all the way down to Meadow, and we've lost all of those natural barriers, this small space is still significant. We as a city are losing that because we have nonstop building right now. We look more like Boston than we look like Portsmouth. And downtown is very congested, but we all purchased outside of downtown because of the green space that it provided and what it provided for our families. And I think the integrity of that is extremely important to all of us. But I think it's important to us as a city before we lose all of that in this overdevelopment. At some point, we have to follow these ordinances. They are in place for a reason, and they exist for a reason. Otherwise, why are they in place? This property isn't even half the size of what it should be to meet the ordinances. It's less than half. That's significant. And you can't compare structures that have existed since the 1900s near the old Frank Jones area. All of the houses on our street that directly abut this have 15,000 to 20,000 square feet. This is a significant difference to our neighborhood. Thank you.
Thank you. Okay, last call. See, Zoom.
Yep. Catherine Campbell.
Hi, thanks. Catherine Ozier Campbell, again, 75 Ruby Road. I just wanted to, really, again, remind the board and thank you for your time here. But, we're looking at this in the spirit of the ordinance, which is appropriate size properties for building upon. And, I can certainly respect, the comments that were made earlier regarding some of the other lots that you might find in the city where that's different. But again, we're talking about a lot where there has not existed a structure. We're not looking, it's not like they're looking to rebuild something where there already was. We're talking about taking a space that's already too small and then filling it, with a home, which just seems a little bit, out of the spirit of the ordinance, which I would guess was put into place to protect other properties, surrounding it. Thank you.
Thank you. And Mr. Smith, we clear on Zoom?
Yes.
Okay. Okay, the public hearing is closed. It's 8:30, we're all set, not in danger of the 9 o'clock break. Does anyone want to start the discussion on this one?
Just have a
Any
question
initial
for-
thoughts? Yes,
for
yes,
staff,
Ms.
please.
Marchison.
So the proposed right yard setback is 16 feet, and the minimum is 30 feet.
It's a copy and paste. It's 10. This is the right yard.
You're right, 10 feet on the side yard setback.
Okay. So instead of 30, it should be 10?
Right.
Okay, so that's a mistake. Okay.
Supposed to be, yeah.
Be a heck of a right yard setback. I have a couple of general comments.
Yeah, yes, please, Mr. Hageman.
So I read all the communications that came in from the public and heard all the testimony tonight, and certainly understand concerns about the, nature of what this property would end up being and the purpose for why it might have been unmerged. I think those are honestly distinct different things. The unmerger is something that could be done by right as a result of that property and the law at the time. And then knowing that Miss Rayburn is the one who sold this property at a time when development was at a peak, communicates to me that maybe her sentiment had changed about what that property could be used for longer term. So given that there's no binding contracts or deed restrictions or anything of that nature on the property, not to say that justifies this particular house and this particular project, but the spirit of that, I think, is diminished a little bit given the context in which the property was sold and how it was unmerged. That's just sort of my broad overview. And then there was a reference to a case in 2019 for a property either across the street or a little deeper into the neighborhood that the board denied a variance on. I think I was on that case. And from what I recall, and I obviously would want to go look back at the record, but from what I recall is that property also had a giant telephone wire easement going through it, and the property that would have remained from the subdivision was basically a basin for all the water in the neighborhood to be caught there. So it would have been rather disruptive to stormwater runoff if someone put a house on that particular lot. So I don't think those are terribly comparable. There's been no representation that this lot serves a similar purpose in this part of the neighborhood. So I just wanted to give a little background there. I remember the facts of that case in 2019 a little differently than how they've been represented here.
Anybody on this side want to chime in? Ms. Martinson, thank you.
Just to follow up on those comments, you know, I always have sympathy for abutters, and your concerns, stormwater concerns, and wanting green space, and that's something that I certainly would support. However, this is a private property. The city has no purview to keep this as green space. You know, there's nothing that this board can do to ensure green space in the neighborhood when we're talking about private properties. You know, this property is very unique. I mean, I did look at some of the other properties in the area, and the sizes do vary. There's some properties, at least according to the tax maps, that are actually smaller than this property. So it's this neighborhood, particularly on that side of Woodbury, appears to be a little bit all over the place. So those are just my general thoughts.
Thank you. Anybody else down? Mr. Lee. Mr. Marossi.
My question is to the rest of the board, you know, as one of the newer members. How is the question of substantial justice addressed when there are so much opposition to a project that's non-conforming from the abutters? I mean, is that a consideration in determining substantial justice?
Well, I think it says,
Mr. Lee?
if I may, it says in our requirements for granting a variance, a suggested approach, substantial justice is the benefit to the applicant should not be outweighed by harm to the general public or other individuals. So the benefit to the applicant should not be outweighed by harm to the general public or other individuals.
So the short answer is yes, to some extent. The abutters, the impact of the abutters certainly as a factor in that consideration, but it's not the only factor.
It's perceived harm, but is it really harm?
Right, so that's part of the, I guess, the analysis of the board is determining if what's a perceived harm is actually a harm and whether it meets the criteria of you know, some right to the public that exists that would supersede the applicant's desire for the variance here.
Thank you.
Hindsight in all these matters is always 20/20. If it were truly the desire of the lady that owned the lot and sold it that it not be developed, a deed restriction for that would have been very simple to put in when the lot was transferred, and that would have we wouldn't be here tonight. But that was not done, and for whatever reason. Going forward, when the purchasers bought the lot, it's a very simple, when you buy a lot, to put a contingency in the offer to purchase that, you know, I'll buy that lot if I can do this. We wrote an offer just today on another property that we put a contingency in it that our buyer client had to sell her house in order to buy this property. It's 2 sentences long in the offer to purchase. So I think that real, you know, due diligence 101 was not observed there by whoever for whatever reason. I think this is a pretty small lot, and the ask for the variance request is pretty big. In my opinion, this is a bridge too far to build a house on this lot, so I think it would be contrary to the public interest, and it wouldn't observe the spirit of the ordinance. So for those reasons, I wouldn't be supporting this application for a variance.
Okay, are we, any other comments before I try to encourage a motion?
We need to know who's voting.
Oh, yeah, who's that?
Ms. Eldridge, sorry.
Honestly, I don't recall.
In the order, I have
Afraid-
Mr. Hageman in,
You're
Ms.
in.
Eldridge out.
You're in.
I've been quiet.
I'm sorry, yeah, I should have said that before.
I'm tagged in.
You're in. Very good. Anybody else before? Mr. Lee, were you warming up to a motion?
I would move to deny this application.
Is there a second to that motion?
I'll second it.
Thank you, Mr. Rossi. Mr. Lee, your motion, please.
Well, for the reasons I've stated, and I'll reiterate, in my opinion, this variance is contrary to public interest, and it doesn't observe the spirit of the ordinance. I think the request is pretty massive. I mean, they're out asking to build a house where you need 15,000 square feet. They have 7. You're supposed to have 100 feet frontage. They have 60, so it's just not enough. And for those reasons, I would move that we deny this application.
Mr. Rossi, a second?
I agree with that, and I further say that I don't believe it meets the test of substantial justice.
All right, thank you. Any comments from this side? No? Ms. Margison?
I will not be supporting the motion. I find that this property does have special conditions. It's a non-conforming lot that was unmerged through the city process. Without some kind of zoning relief, it would not be able to be built upon. It is a matter of right in the single residence B district, and therefore I would support a motion to grant the variance request.
Okay, you know the motion's on the...
Yes, I know. I'm just
okay.
saying I will not be supporting it.
Okay. Okay. Doesn't get any easier, does it?
Mr. Chair. Mr. Chair.
Yes, Mr. Hagan.
Just a quick comment as well.
Yes, please.
To piggyback off Ms. Margison, I agree with her. I won't support this motion because after reviewing the application, looking at the criteria and hearing all the testimony we have, the requests that are being asked are by virtue of how the lot itself exists as a result of an unmerger, which was a statutory right. And I think what is being proposed to be done here is really reasonable. It's not a huge house. It fits within all the other requirements of the envelope of the lot in terms of setbacks. There's been no indication that this would in fact worsen stormwater runoff. It doesn't alter the character of the neighborhood. It's a single residence, single-family residence in a predominantly single-family residential area on a rather busy street in our community. And there are a number of other lots that are, if not similarly sized, not much bigger as you go down Woodbury. So I don't know if focusing on just the cluster of houses immediately around this property is fair in terms of how we characterize the neighborhood. So for those reasons, I'm not going to support this particular motion. And like Ms. Margison would otherwise support a motion to grant the variances.
Okay. Is anything else, anybody else have anything to say before we take a vote? No? Okay. I can't remember, alternating, I can't remember, well, it doesn't matter. We'll start out down at the left-hand side there. Mr. Lee?
Yes.
Wait a minute, let me get on the right street here.
And this is the motion
This
to
is the motion-
deny.
The motion is to deny. The
Thank
motion
you.
is to deny. Yeah. Mr. Stitt's keeping score along with
Yep.
me, keep me honest here. Mr. Rossi?
Yes.
Ms. No, you're not voting. Ms. Margison?
No.
No.
I got you covered. if you
Okay,
want.
all right, good. Let's start down here. Mr. Manow?
No.
Okay, Mr. Hageman?
No.
And Mr. McDonald?
Yes.
Yes. Mr. McDonald, yes. And the chairman votes no.
The motion fails 3-4.
3-4. So that was a motion to deny which failed. So I would propose that we need a motion to approve.
You want it or you want me to do it?
You do it.
Of course. Mr. Chair, I'd move to grant the application for variances as presented.
Okay? Okay, we'll start We'll start down this way.
Is there a second?
I think we need a second
Second?
first.
Second?
I'll second.
Ms. Martin,
I
second.
just assumed
Okay.
you were going to second, sorry.
Okay. Okay, this motion is to grant the application. Approve it. In other words, approve it. Okay. Mr. Mantle?
Oh, I gotta do the motion first.
Okay.
Sorry. I'll go. So I'll, I guess, retread some of the tracks I've already laid down. Looking at the 5 variance criteria, we take 1 and 2 at the same time. So will the variance be contrary to the public interest? No. It doesn't violate basic zoning objectives. It doesn't alter the essential character of the neighborhood. It doesn't threaten the health, safety, or general welfare of the public. We heard a lot of concern about what could impact stormwater or how it might change the neighborhood. But again, this application is for a single-family home in a single-family neighborhood, and there's been no indication that there will actually be any impact on stormwater or runoff. For that reason, the spirit of the ordinance is observed. It's a relatively modest home on, albeit a small lot, but there's no significant issue, in my view, with air, light, water. Substantial justice is done. There's no gain to the public in this circumstance that outweighs the loss to the individual should we deny this application and not permit this single-family residence to be built on this lot. There's been no evidence that values of the surrounding properties will be diminished. In fact, we're in an environment where just about anything you put on a lot is going to increase the value of that lot and the surrounding properties. Literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. As was mentioned earlier, this was an unmerged lot, so the size of the lot can't change, the frontage of the lot can't change, and those are the 2 variance requests before us. And there's no fair and substantial relationship between the general public purposes of the ordinance and the specific application here. And the proposed use is a reasonable one. Again, I've said it a few times, but single-family home in a single-family neighborhood with comparable lot sizes to many lots on Woodbury. And for those reasons, I believe it is an application worth granting.
Ms. Martinson?
I have nothing to add.
Okay. Anything further before we take the vote? Last call? Okay. Don't get any easier, do they? The motion is to grant, approve. Mr. Mantle?
Yes.
Mr. Hageman?
Yes.
Mr. McDonald?
Yes.
Mr. Lee?
No.
Mr. Rossi?
No.
Ms. Margison?
Yes.
And I vote yes. So, the count is 4-3?
5-2.
5-2, rather, yeah. 5-2, the request is approved. All right, anything before we,
Because of where,
They wanted wasn't theirs to have.
because it's in the SRP.
and just,
It's the house that gets towards
just for the
half the size.
interest of everyone who's still here, the last item, as previously announced,
Approved
for
unanimously.
property at 389 Lincoln Avenue has been postponed. Will not be heard tonight, it will be heard next month. That's the last item on our agenda, but before we close, I think it would be only fair that we recognize the service of 3 menu.
Please
Three
go.
Hey, guys.
folks, could you
Hey, guys.
Thank
could
you,
you
Derek.
take it out, please?
Go outside.
They're making noise.
Please.
Sorry.
Thank you very much.
Loud.
I just think it's appropriate if we recognize the service of the 3 members who are no longer with us. Attorney Chris Mulligan used to sit right there. Chairman Dave Rayom, who used to sit
Still alive.
right in this seat, and Vice Chair Pete McDonald, who used to sit right there. And just speaking for myself, I think they were out very dedicated for people who came prepared. They were a pleasure to serve with. They always attuned to the issues, kept up with the homework, put in the time and effort, and the public owes them a thank you for their service. And if anybody has anything to add to it, I'd be pleased to have it, hear it.
I'll just add that when I first joined the board as an alternate, I learned a lot from the board and from those members in particular as well. So I appreciated their service and all they taught me along the way.
Thank you, thank you. Again, Mr. Lee.
I'll just add, I always enjoyed their former chairman's comments about our TV viewer audience, and I suspect it was far greater than the 5 he always
Strong
alluded to.
ratings.
Oh, 7.
Yeah,
Strong ratings on a Tuesday night.
yeah. Yeah, I guess one last mention, we're talking about it. Attorney Chris Mulligan, Chairman Dave Rayum, and Vice Chair Attorney Pete McDonald. And we thank, and on behalf of the public, I think we can thank them for their service, which was
We do, yes, definitely.
long and very well done.
Here.
So, yeah.
Yes.
Anything further before we adjourn? Does anybody want to make the motion that I usually used to make?
I move we adjourn.
Thank you, Ms. Eldridge. And Mr. Lee seconded. We're done.